A major ruling has just been issued with a unanimous 9-0 decision that almost no one expected, and it is about to reshape what you thought you understood about your gun rights and what law enforcement can do during a traffic stop. If you own a firearm and also drive, what you are about to hear over the next few minutes could be the difference between calmly driving away or standing on the roadside in handcuffs, wondering how the situation escalated so quickly. Before we dive in, do one quick thing right now. Make sure you are subscribed. Most gun owners never hear about critical rulings like this until months later, or worse, until they are hearing about them from an officer standing at their car window. I do not want you to be in that position. Stay informed and stay ahead. Now let's break down what just happened. The case that led to this unanimous decision centers on a constitutional conflict that has been building for years. On paper, the two rights involved are very clear. The Second Amendment protects the right to keep and bear arms on. The Fourth Amendment protects citizens from unreasonable searches and seizures. Two separate constitutional guarantees, two core liberties. But what happens when those two rights intersect during a routine traffic stop? For years, courts across the country struggled with a straightforward but extremely important question. If an officer knows there's a firearm in your vehicle, even a completely legal one, does that automatically justify searching the vehicle without a warrant? Some lower courts were beginning to lean toward yes, and that is where the situation became genuinely concerning for law-abiding gun owners across the United States. Because think about what that actually implies. If simply exercising your constitutional right to carry a firearm automatically weakened your Fourth Amendment protections, then one right would effectively cancel out the other. You would be forced to choose between being armed and being protected from warrantless searches. That is not how constitutional rights are supposed to function. That is not what the founders intended. And that exact conflict is what this case forced the Supreme Court of the United States to resolve. The case that reached the High Court began the same way. Many of these cases begin with a routine traffic stop. Picture yourself driving home. Maybe you have your concealed carry firearm on your person or your range bag sitting in the back seat. You get pulled over for something minor, a broken taillight, or maybe going a few miles over the speed limit. In the case before the court, the officer approached the vehicle and discovered during the interaction that the driver had a firearm. The driver was cooperative. He was not reaching for the weapon. He was not behaving erratically. He remained calm and respectful, but the officer treated the presence of the firearm as automatic justification. He claimed that because a weapon was present, he had the authority to search the entire vehicle without a warrant. There was no probable cause of a crime, no additional suspicious behavior, only the presence of the firearm itself. Here is the part that surprised many observers. The lower courts agreed with the officer. They ruled that if a firearm is present in a vehicle, even if it is legal, that alone gives officers the authority to conduct a full vehicle search. Consider the weight of that decision. Your Second Amendment right to own a firearm would effectively override your Fourth Amendment right to privacy. Then the case moved to the Supreme Court, and what happened next sent shockwaves through the legal community. All 9 justices, from the most conservative to the most liberal, reviewed the situation and unanimously said, no, this was not a narrow 5-4 ruling. This was not a divided ideological outcome. It was a complete 9-0 decision. That alone highlights how significant the ruling is. Here is the core holding of the court. The mere presence of a legally possessed firearm inside a vehicle does not, by itself, create probable cause to search that vehicle. Let that sink in. Legal gun ownership is not suspicious behavior. Lawful carry is not evidence of a crime, and law enforcement cannot treat it that way. The justices made this point very clear. A citizen cannot be treated like a criminal suspect simply for exercising a right explicitly protected by the Constitution. The court directly told law enforcement that exercising one constitutional right cannot be used as justification to strip away another. 9-0. No dissents. No partial disagreement. No ideological split. When all 9 justices agree on an issue involving firearms and search authority, it signals that the constitutional boundary is not unclear. It is firmly defined. Now, let's slow this down and explain why this matters so much in practical terms. During a traffic stop, officers already have certain established powers. Courts have long ruled that officers can order drivers out of their vehicles for safety reasons. That has been settled law for decades. However, searching your vehicle involves a completely different legal threshold. Under the Fourth Amendment, a warrantless search generally requires one of two things: a warrant or probable cause. Probable cause means the officer must have specific, articulable facts suggesting that a crime is being committed. Not a hunch, not a possibility, not a just in case assumption. For years, some departments treated the presence of a firearm as automatically creating enough safety concern to justify broader searches. The reasoning was simple: firearms can be dangerous, so if one is present, a search is necessary for officer safety. But that logic creates a major constitutional problem. Millions of Americans legally carry firearms every day. In many states, constitutional carry laws allow adults to carry without a permit at all. If lawful firearm possession automatically justified a search, then a massive number of law-abiding citizens would effectively lose their Fourth Amendment protections the moment they exercise their Second Amendment rights. That is the constitutional conflict the Supreme Court addressed and shut down. Now, let's bring this into a real-world scenario. Imagine you are pulled over for a broken taillight. The officer approaches and asks for your license and registration. Then the officer asks whether you have any weapons in the vehicle. In some states, you are legally required to disclose that information. In others, you are not required but may choose to disclose. You answer honestly, "Yes, officer, I have a legally carried firearm in the glove box." Before this ruling in certain jurisdictions, that answer alone could escalate the stop. Officers could use that disclosure to justify searching the entire vehicle. After this 9-0 decision, that justification does not stand by itself. The presence of a legal firearm does not equal probable cause. That distinction is extremely important, and it changes the legal landscape for every gun owner who drives. But there is something important you need to understand. This ruling is not a universal shield. It does not instantly eliminate every questionable police practice across the country. Court rulings establish legal standards, but how those standards are applied depends heavily on the specific facts of each situation. And that is exactly where situations can still escalate if you are not careful. The court ruled that a legally possessed firearm alone does not create probable cause. But the key phrase is alone. The moment additional factors enter the picture, the legal analysis changes. Let's look at some real-world examples to make this clear. First, prohibited persons. If someone is legally barred from possessing firearms due to a felony conviction, a domestic violence restraining order, or any other disqualifying condition, and an officer has reason to believe that applies, the presence of a firearm is no longer neutral. It becomes potential evidence of a crime. This ruling does not protect unlawful possession. Second, visible violations. If a firearm is in plain view and state law requires it to be stored in a specific manner, such as unloaded, secured, or inside a locked container, and the officer clearly observes a violation, that becomes an articulable legal issue. Again, the firearm itself is not the problem. The unlawful method of possession is: third, additional suspicious behavior. If during the stop the officer observes drug paraphernalia in plain view, detects the odor of illegal substances, hears contradictory statements, or notices attempts to conceal items, the firearm may become part of a broader probable cause determination. The court made it clear that lawful gun ownership is not suspicious activity, but it did not eliminate existing Fourth Amendment doctrines. The automobile exception still exists. Under that doctrine, officers may search a vehicle without a warrant if they have probable cause to believe evidence of a crime is present. The Supreme Court did not remove that principle. It clarified its limits. A legal firearm is not probable cause, but independent evidence of a crime still can be. Now let's discuss something that is rarely addressed but extremely important. Even with this unanimous 9-0 ruling, there is still a significant gap between the law as written and the law as it is experienced on the roadside. Supreme Court decisions do not instantly retrain every officer in every department across the country. Policy updates take time. Training cycles take time. Cultural shifts take time. And during that transition period, you are the one standing on the side of the highway, dealing with the reality of the moment, not the ideal version of how the system is supposed to work. That gap is real, and ignoring it can create serious problems. Imagine that you have remained calm and respectful. You have clearly stated that you do not consent to a search. You have kept your hands visible on the steering wheel. But the officer says he smells something, or claims he is conducting a search for safety reasons anyway. This is the moment that matters most. Not your knowledge of the ruling, but how you respond in that moment. Do not resist. This is one of the most common and costly mistakes people make during traffic stops. If you physically try to prevent an officer from searching your vehicle, the situation immediately shifts from a constitutional issue to a potential resisting charge. You do not win that argument on the roadside. You win it later in court. By remaining calm, clearly stating that you do not consent, and avoiding interference, you are creating a legal record. You are allowing the officer's actions to stand on their own under legal scrutiny. Your composure is not weakness, it is strategy. And this is where the practical impact of this ruling becomes most important. If a search is conducted solely because you disclosed a legally possessed firearm, this 9-0 decision gives your attorney significantly stronger legal footing. But first, you have to get through the traffic stop correctly. You have to preserve your rights by exercising them properly in the moment. So let's walk step by step through what that looks like. Picture the scenario. You are driving home. You are legally carrying a firearm. Everything is lawful. Suddenly, emergency lights appear behind you. The first thing you should do after stopping is control your environment. Turn off the engine. Roll down your window. Place both hands visibly on the steering wheel. If it is nighttime, turn on your interior light. You want the officer to immediately see that you are not a threat. Officer safety concerns influence many roadside decisions. The calmer and more predictable you appear, the lower the tension during the interaction. That matters more than many people realize. The officer approaches and asks for your license and registration. Here is a mistake that undermines many cases before they even begin. Do not suddenly reach toward the glove box if your firearm is located anywhere near your documents. Instead, remain still and speak first. Calmly say, "Officer, my registration is in the glove box. I want to let you know I am legally carrying a firearm, and it is also in the glove box. How would you like me to proceed?" That single statement accomplishes several important things at once. It shows cooperation. It demonstrates awareness. And it significantly reduces uncertainty, which is often what causes traffic stops to escalate. Now let's talk about disclosure requirements. Some states legally require you to immediately inform an officer if you are carrying a firearm. Other states do not. This ruling does not change those state-level requirements. You should know your state law before you ever begin driving. If your state requires disclosure, comply calmly and clearly. If your state does not require disclosure and the firearm is not visible, you are not legally required to volunteer that information unless the officer asks directly. However, if you are asked, never lie. Providing false information to law enforcement can quickly transform a routine stop into a criminal situation. Now we reach the moment that often determines how the encounter unfolds. The officer asks, "Do you mind if I search your vehicle?" This is where constitutional knowledge either protects you or disappears. Consent changes everything. If you say yes, even casually or simply to appear cooperative, you have effectively waived your Fourth Amendment protections in that moment. This Supreme Court ruling protects against searches based solely on the presence of a legal firearm. It does not protect against voluntary consent. So what should you say? Keep it simple and calm. "Officer, I do not consent to any searches." That is all. No lectures, no arguments. No roadside constitutional debate. You are not required to explain your reasoning. And here is something many people misunderstand. Refusing consent does not create probable cause. An officer cannot legally justify a search simply because you declined. Refusal is a protected exercise of your rights, not evidence of wrongdoing. Now let's address a common follow-up statement officers sometimes use. If you have nothing to hide, why not just let me look? This is psychological pressure designed to make refusal feel suspicious. Do not take the bait. Remain steady and respond calmly. I respect your job, officer, but I do not consent to searches. Then stop talking. Silence is often one of the strongest legal protections you have during a traffic stop. Here is a mistake that weakens more Fourth Amendment cases than almost anything else: talking too much. Once you have clearly refused consent, stop volunteering information. You are required to provide identifying documents. You are not required to answer investigative questions such as, where are you coming from? Where are you headed? Is there anything in the vehicle I should know about? You may politely respond, I prefer not to answer additional questions. That response is lawful and protects your legal position. If a search still occurs and you believe it is unlawful, do not resist physically and do not interfere. Instead, clearly state, I do not consent to this search. Say it loud enough to be heard. That verbal record can become extremely important later in court. As soon as the traffic stop is completely finished, document everything while the details are still fresh. Write down the time and location. Record the officer's name and badge number, if available. Note exactly what was said, whether consent was requested, whether you refused, and what reason the officer gave for the search. Memory fades faster than most people expect. Details often determine how legal cases are resolved. Now let's step back and look at the broader legal landscape, because geography plays a major role in how your rights apply. There is no single uniform framework for firearm laws across the country. Each state maintains its own rules governing concealed carry, open carry, reciprocity agreements, duty to inform requirements, and how firearms must be stored inside a vehicle. The moment you cross a state line, your legal responsibilities, and sometimes your legal protections, can change. This ruling strengthens Fourth Amendment protections at the national level, but it does not override valid state-level firearm regulations. If you are unknowingly violating a state carry law, even unintentionally, an officer who reasonably believes a violation is occurring may still establish probable cause. Not knowing the law in a specific state is not a constitutional defense. That is why this decision protects lawful possession, not mistaken possession. The protection applies only when your firearm possession is fully legal in the jurisdiction where you are located. If you travel with a firearm, you must research reciprocity and storage requirements for every state you pass through. This is not optional. It is part of responsible firearm ownership and part of ensuring that the legal protections discussed here actually apply to you. Now let's bring everything together. This ruling represents one of the most significant constitutional clarifications for law-abiding firearm owners in recent years. The court made it clear that exercising one constitutional right does not automatically weaken another. You can legally own or carry a firearm and still maintain your protection against unreasonable searches. But constitutional protection does not eliminate personal responsibility. This ruling only applies when your possession is lawful. So, it only helps you later in court if the roadside interaction was handled correctly, and it only protects you if you do not unintentionally give away your rights by consenting to a search, making inconsistent statements, or creating unnecessary tension during the stop. So here are the practical takeaways moving forward. When you pull over, keep your hands calm and visible. Communicate clearly when the officer approaches. Avoid sudden movements. Do not give voluntary consent to searches. Do not turn the roadside into a constitutional debate. Know your state's firearm laws. Understand reciprocity rules if you travel. Store firearms according to state requirements. Maintain valid permits where they are required. Because the moment your possession becomes unlawful, even accidentally, the protection discussed in this ruling disappears. Most people will never hear a detailed explanation like this. Many firearm owners only learn about constitutional boundaries after something has already gone wrong, after a search has already occurred, after charges have been filed, or after an arrest has already taken place. By taking the time to understand this information now, you are placing yourself ahead of the majority of people who carry without fully understanding how these legal principles apply in real-world situations. Knowledge alone does not prevent problems, but it dramatically improves how you respond if a situation arises. Stay informed, stay calm, stay lawful, because constitutional rights are strongest when the people who hold them understand exactly how to exercise them properly. And the next time you see emergency lights in your rearview mirror, you will know exactly what to do and what not to do. This is educational information about constitutional law. It is not legal advice for your specific situation. Laws vary by state, and the facts of every individual traffic stop matter. The details of how an interaction unfolds can influence how legal standards are applied, and outcomes can differ depending on the specific circumstances involved. If you ever face a legal issue related to firearm possession, vehicle searches, or any roadside interaction, consult a qualified attorney who practices in your jurisdiction. A licensed attorney can evaluate the exact facts of your situation, apply current state and federal law, and provide guidance tailored to your case. Understanding your rights is important. Exercising them responsibly is essential. And when legal questions become personal, professional legal advice is the only reliable path forward.